Hey, I'm going to bring you up to speed on some developments in the Eastern District of Virginia and two criminal cases there that are of interest to my audience. You probably know that in the Eastern District of Virginia, there's the case against James Comey and there's the case against Letitia James. Both of those cases were signed by former Trump attorney Lindsey Halligan, who was appointed to serve there. And the way this all went down is that back when Trump took office, or right before, on January 17th of this year, Jessica Aber announced her resignation as the U.S. attorney for the Eastern District of Virginia. When Trump got into office on January 21st, he appointed Eric Siebert to be the interim U.S. attorney for the Eastern District of Virginia. That allowed Siebert to be there for 120 days. After 120 days, Trump could there would either need to be a Senate confirmed U.S. attorney who took that spot, or the District Court of Eastern District of Virginia could vote to retain Siebert until there was a Senate confirmed U.S. attorney, or, and this is of some debate here on this specific issue, Trump could appoint someone else to be the interim U.S. attorney. Well, what happened was, how many stories start off with that initial phrase? What happened was Eric Siebert had been getting pressured to bring an indictment against James Comey and against Letitia James. And prosecutors in his office had told him, we don't think it's a good idea. There's not enough here to bring a indictment against those two. And even if there is enough to bring an indictment against Comey or Letitia James, there's not enough here to sustain a conviction of them. And Siebert declined to bring it, and prosecutors wrote declination letters about it, and Trump was not happy about that. And Siebert ended up resigning, or Trump fired him, one or the other. It's of debate. Well, then Trump took to Truth Social and made this post where he complained to Pam, and there's some rumors going around that this was actually meant to be a direct message to Pam, because that's how it reads, instead of an actual Truth Social post. Personally, I don't believe it was meant to be a direct message. I think that it was meant to be a public message, and then Trump deleted it to increase the intrigue around the whole subject. But Trump made this post to Pam, I have reviewed over 30 statements and posts saying essentially the same old story, blah, 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 blah. You've probably read this post, and it comes up in the filing we're going to read. So right after this, right here, Trump is saying next he said, we got to appoint Lindsey Halligan. Lindsey Halligan's the only person who can get it done. There she is right there. Actually, my face is in the way. Lindsey Halligan is a really good lawyer and likes you a lot. Oh, it's so Trump. It's theater carnival barking Trump. It's also a bit boomer Trump. Don't get offended, boomers. I love you, boomers. Don't get offended. So Lindsey Halligan here, former insurance attorney, former Trump defense counsel. She defended him in other cases. I'm not sure if any of them she won. I honestly don't know. But Trump appointed her to be the interim U.S. attorney for the Eastern District of Virginia, giving her a 120-day term. And the attacks began on her, of course. And I think Trump expected that and wanted that. And a couple days after she was appointed there, about 5 days later, she's formally nominated to be the attorney for the Eastern District of Virginia. Here's her nomination. It's in Congress right now. She hasn't been confirmed by the Senate. Well, they bring the indictments against James Comey and against Letitia James. And as I've already covered on this show before, I didn't cover the James one, but I covered the Comey one. The motion to dismiss this indictment based on the unlawful appointment of Lindsey Halligan. And I covered that. I'm pretty sure it's a video on my YouTube channel. And on my Rumble. Whatever. It's there somewhere. I know it's in pretty sure it's in episode 350. So I found that motion compelling because there is some question about whether or not a president can make successive 120-day interim U.S. attorney appointments. And there's been some debate this year about that. And the same thing happened with Alina Habba, and a court ruled her appointment was unlawful. There's another guy in Nevada. There's another guy in Southern California. And all of their appointments have been challenged. And the judges that reviewed it either ruled that they were unlawful or ruled in part that they were unlawful, but they could continue serving in some capacity. And with Alina Habba, after she was removed by a judge, and it's now at the Third Circuit Court of Appeals, AG Bondi said, well, Alina Habba is also a special attorney employed by the AG's office, and she's been empowered to run that office and bring prosecutions and other proceedings. And nobody's been, as far as I know, none of these challenged U.S. attorneys have been completely removed from office and are just have nothing to do with where the district they were appointed with. As far as I know, they're all still working in those offices, at least on paper and as advertised, they're still working there. But they're not specifically called the interim U.S. attorney serving a 120-day appointment. And I told you guys, like, I think that this is, in fact, what I said about Comey is that I thought it was a kill switch. I thought it was an intentionally installed kill switch to this case, Lindsey Halligan's appointment, and that I thought the motion to dismiss her for unlawful appointment would result in this case collapsing. Because if she was appointed unlawfully, that means she didn't have authorization to bring about the prosecution, and therefore the prosecution must be dismissed, because the person who took it to the grand jury, got them to sign off of it, and put her signature on that indictment, on the complaint, shouldn't have been there and shouldn't have been able to do that. And that's the argument that Comey and his lawyers, who are high-power lawyers, that's what they argued in their motion that I've covered here, and I found it compelling. Well, James Comey and Lindsey Halligan both filed that motion. Actually, before I get to this post, both of them filed that motion, and what ended up happening is that the judge in both of these cases said, look, a challenge to the U.S. attorney who's over this case can't be heard by the judge who's actually on the case. It needs to be heard, and is in that district. It needs to be heard by a judge from a different district so that there's some separation there. And the judge who was assigned this matter for both of these cases is South Carolina, senior judge out of South Carolina, Cameron McGowan Curry. And so he's handling all matters having to do with the appointment of Lindsey Halligan. Both sides filed their motions to dismiss, and now DOJ has responded. And by DOJ, I do mean DOJ. It's not just a filing from Comey's attorneys and a filing from James's attorneys. It's a filing from both of them, or the prosecutors in those cases. It's a filing from prosecutors in both of those cases, plus the personal attorney to the AG, to Bondi. His name is Henry Whitaker. And Henry Whitaker, I'm going to go ahead and jump ahead to who Henry Whitaker is. I have it right here. Henry Whitaker is called counsel to the Attorney General, and before he was in that position, he was the Solicitor General of Florida. And before that, in the first Trump admin, he served in DOJ's Office of Legal Counsel, and he was appointed at the beginning of this current Trump admin to be the lead of the Office of Legal Counsel at DOJ. And his name was up on their website for a few days, and then it was removed. And then he pops up as counselor to the Attorney General. Not sure what's up with that, but something I think my audience would really appreciate knowing is that before he did those jobs, he was on the appellate staff at DOJ Civil Division, and he argued 40 plus cases in front of the Federal Appeals Court. And before that, he clerked for Justice Clarence Thomas, making Henry Whitaker a really good person to have on your side in any legal filing that has to do with the appointments of people and appellate issues and questions of the Constitution and statutes and all of those things. So Henry Whitaker is a big gun. Comey's got big guns on his team too, but Henry Whitaker, he seems like, I don't know. This guy seems like kind of a big deal, let's say. And his filing, which I've read a lot of filings, almost every single one, on United States v. Comey. Many of them I've read 3 times over, and I've recorded videos and have been publishing those videos of me reading them to you guys. And then I've also read a lot of filings in the James case, and I've familiarized myself with the way the prosecutors in these cases write. It starts to come across, you kind of start to recognize their syntax and the structure of their filings and all these things. This one's different. This one's different. And I think Henry Whitaker wrote the whole thing, and then the other attorneys just said, okay, we'll sign off on that. And you can see the other prosecutors here. Lindsey Halligan is up top, then Whitaker. Roger A. Keller is the attorney who's prosecuting Letitia James. By the way, he's from Missouri, not Eastern District of Virginia. And then the prosecutors against James Comey are Nathan Tyler Lemons and Gabriel J. Diaz. They're out of North Carolina. There are no EDVA prosecutors signing these filings in these cases, which is strange. All right, now, here's what we learn in this filing, which I'm going to do a different video where I read the entire filing. You can look for that. I think it's well worth reading the entire thing. It's actually really enjoyable to read it. But for this video, what I'm going to do is I'm going to give you a brief overview to this filing and what it says. And the first thing to note is it has an attachment. And this attachment is from AG Bondi, and it was signed on Halloween, October 31st. And it says, yeah, Lindsey Halligan is appointed to be the U.S. attorney. And if a court rules that she's not lawfully appointed, well, then guess what? I'm retroactively making her a special attorney as of September 22nd, 2025. And I'm giving her the authority to conduct legal proceedings in the Eastern District of Virginia. Should a court conclude that Ms. Halligan's authority as special attorney is limited in particular matters, I hereby delegate to her authority as special attorney to conduct and supervise the prosecutions, specifically of James Comey and Letitia James. I've never read anything like this. I've never read an order from an AG that is like this. I'm not calling it into question. I'm not saying it's nefarious or there's something wrong about it, but I don't know any other way than to read it as retroactively, as of Halloween of this year, going back in time and making Lindsey Halligan a special attorney. And then failing that, saying, I'm delegating her the authority to prosecute Comey and James. It also says, I've reviewed the grand jury proceedings in Comey, United States v. Comey and United States v. James, and I hereby exercise the authority vested in the Attorney General by law to ratify Ms. Halligan's actions before the grand jury and her signature on the indictments returned in each case. So this is the office of the Attorney General stepping in and saying, I'm authorizing all of this. I'm empowering all the people that have to do with it. I've personally reviewed these prosecutions and I endorse them. I've never seen anything like that. Not saying it's wrong or anything like that. I'm just saying I've never seen anything like this. Okay. Now, what does this filing argue? Well, it's very, very compelling. It says the sole question at issue here on the unlawful appointment of Halligan, the sole question for Judge Cameron McGowan Curry to resolve is whether Section 546 authorized the Attorney General to appoint interim U.S. Attorney Lindsey Halligan in the circumstances here, where A previous interim U.S. attorney, that would be Siebert, vacated office after 120 days and was then reappointed by the district court, and whether or not another attorney can be appointed to serve another 120 days as an interim attorney. And the answer is yes. All parties here, the U.S., the prosecutors in each team, the defendants on each team, and their counsel agree that the office of U.S. attorney for this district was vacant when Ms. Halligan was appointed. And no one claims that subsection B applies, which subsection B of section 546 says you can't appoint someone that the Senate has already rejected. And Ms. Halligan's appointment hasn't been rejected. It hasn't been given its full, it hasn't gone fully through the process. It's still waiting. The last action on it was a month ago, where it was received in the Senate and referred to Committee on the Judiciary. That's the last thing to happen with it. Oops, clicked the wrong tab. So they haven't rejected her, which means she's eligible. The next section of 546 permits a person appointed under that section to serve until the expiration of 120 days after her appointment or his appointment. And we haven't exceeded 120 days. The Attorney General gets to revisit that choice periodically, consistent with the nature of interim appointments. Even were Ms. Halligan's appointment invalid, if it was, any government attorney can present a case to a grand jury or sign an indictment, and the Attorney General plainly possessed and exercised the authority to make Ms. Halligan a government attorney, as the Attorney General has now confirmed in what we just looked at, that order we just looked at. Moreover, any defect in Ms. Halligan's role does not taint the indictments themselves. She at least was a de facto officer, and any error was harmless, since the Attorney General indisputably could have appointed her in a different capacity to obtain the indictments. In all events, the government has endorsed the prosecutions, and the Attorney General has personally ratified the indictments to obviate any question as to her validity. So, like, Pam Bondi has come in and said, I'm taking full responsibility for this. I gave the authority. I'm endorsing these indictments. I'm ratifying them. Even if the judge tells Ms. Halligan, you got to get out of the Eastern District of Virginia. You can't be here. And you can't have anything to do with these prosecutions. I, A.G. Bondi, am saying that the indictment stands. Never seen anything like it. But they go on to argue that even still, Attorney General did lawfully appoint Ms. Halligan as interim U.S. attorney. And Section 546 and the Appointments Clause and the motion gave her the authority to do so, and the motions to dismiss from James Comey and from Letitia James should be denied. Now, I wasn't too sure about this. In previous episodes, I talked to you guys saying, I read the motions to dismiss, and I was like, I really don't know. And I likened it back to the Jack Smith special counsel, where there was a motion from Trump to dismiss Smith for unlawful appointment to be special counsel. And in my audience, we went through all the filings in that case. And I remember Ed Meese and some other people, former Attorney General Ed Meese, made filings at SCOTUS saying Jack Smith is not lawfully appointed. He's not a Senate confirmed attorney, which special counsels have to be. And it's a misuse of the appropriations clause for the AG to fund his office. He filed that at the Supreme Court, and he filed it in Chutkan and as amicus briefs in Judge Chutkan's court in D.C. and Judge Cannon's court in South Florida. And I read it on the show. I read Jack Smith's responses to it. And I told you guys, I see both sides. On the one hand, I see problems with Jack Smith's appointment. He's not a U.S. confirmed attorney. And it really seems to me, on a plain reading of this section, that you have to be a Senate confirmed attorney to be a special counsel and to have that office. On the other hand, the Attorney General has the express authority to appoint what are called inferior officers to then conduct investigations and legal proceedings in the U.S., either across all districts or whatever districts the Attorney General grants them the authority to exercise in. So it seemed to me more like a problem of what Jack Smith was called. Him being called a special counsel seemed to be the real issue, and he should have been called a special attorney or an attorney with the authority to conduct legal proceedings in these specified districts. But you can't say the Attorney General doesn't have the power to select a prosecutor and empower them to do such and such job. It is the Attorney General's power and authority to do that, and their responsibility to do that. So I saw both sides of it. And when Jack Smith was dismissed, and then the case against Trump thrown out as a consequence of that, I was like, not sure I agree with that. I like it, but I'm not sure I agree with it. I think it's a little bit more, I think there's some more nuance here, and I would have loved to have seen the Supreme Court settle it once and for all. And so with this motion, I'm like, guys, they may have a point. Lindsey Halligan may not be lawfully appointed. And with all the other issues we've seen with Halligan, and then I can't think of the guys, Saley and Chada or something in Nevada and Southern California, it seems like courts are trying to shut this down and say, no, you can't do this. You can't make these interim appointments after there's already been an interim appointment. And the real problem here before that is that the Senate hasn't been confirming Trump's nominations for U.S. attorneys. They haven't been rejecting them either. They just haven't been confirming them. They've just been stalling them out. And so the 120-day period ran out, and Trump made reappointments. And now these courts are saying, no, you can't do that. And the motion to dismiss based on that at least made a decent argument. And I found it compelling. Like I said before, well, here's some things I didn't know. The Congressional Research Service, almost went Sean Connery there. The Congressional Research Service, almost did it again, reports that between January 1993 and March 2006, at least 8 U.S. attorney vacancies, 3 under the Clinton administration and 5 under the Bush administration, were filled through successive 120-day appointments by the Attorney General under provisions of 28 U.S.C. 546, the section at issue here. There was some debate about it. You may remember I think it's called like the Midnight Massacre or something, where Bush fired a bunch of U.S. attorneys. And Congress decided to step in and try and change how U.S. attorneys were appointed. But the thing is, they reverted that. And it was identified during debate having to do with those things that pre-2006, when interim U.S. attorneys served 3 or 4, there were U.S. attorneys who served 3 or 4 successive 120-day terms. And as far as the government is aware, the only district court to consider the practice contemporaneously approved it. So the only time anybody ever challenged it, that court said, no, they can totally do that. As far as and until the current administration, until Trump got in for a second time, no court had questioned that the Attorney General and the President have the power to make multiple interim U.S. attorney appointments. I never knew this. Had no idea. Did you? Did you know this? Citing legislative history, defendants assert that the purpose of the 2007 amendment to Section 546 was to prevent successive interim appointments. But legislative history is not law. And defendants' legislative history reflects the proverbial looking over the crowd and picking out your friends. I love that phrase. I love that phrase. If Congress had intended to block successive appointments in 2007, as the defendants in these cases claim, returning to the former text, which is what they ended up doing, that had long been understood to authorize such appointments would have been a bizarre way of doing so. See, in 2007, they didn't end up keeping the change. They went back to the way things were before. And the way things were before was attorney generals made successive 120-day interim appointments for U.S. attorneys while they awaited Congress or the Senate to approve the president's appointments to that office. That way, there was always someone there to head the office, specifically someone selected by the president and his attorney general, because this is a power that the executive branch has. This is the executive branch's purview. We have Senate confirmation of these things so that it becomes even more powerful, because what it does is it makes it so the U.S. attorney in that office, when they're Senate confirmed, that's two branches of government saying this person is endorsed to conduct legal proceedings in that district. But the Constitution and Sections 546 make clear it is the power of the president and through his AG to appoint people to this office. And he can do so over and over and over again until his appointments by the Senate are confirmed. Under our Constitution, the executive power, all of it, is vested in the president. To the extent there is a dispute over whether a district court or the president should decide who gets to wield executive power, the Constitution provides a clear answer: the president. Historically, courts have overwhelmingly reappointed the Attorney General's choice, as happened with Mr. Siebert here in the Eastern District of Virginia and in multiple other U.S. attorneys in the Fourth Circuit this year. And that's the way it's supposed to happen. While awaiting for his appointment to be confirmed by the Senate, the president, through his AG, gets to make a 120-day interim appointment. If 120 days go by and there hasn't been a Senate-confirmed U.S. attorney, the district court in that district typically keeps the interim appointed attorney. They get the vote. They have the power to do this, to retain them until there is a newly appointed interim attorney, or the president's choice is confirmed by the Senate and takes over. And that's the way it's been until this year, when suddenly judges have decided they got a problem with Trump and the AGs, U.S. attorneys, and so now they're ruling that they're unlawfully appointed, and the president and the AG can't make successive 120-day interim appointments. This is a new thing. And it seems a case of Trump did it, so we don't like it, doesn't it? Now, I'm not surprised at all about this. Of course not. But I love, this is the kind of legal battle and argument that I really enjoy, because I can see both sides of it and appreciate both sides of it. And when a filing like this drops from someone like Henry Whitaker, and it's such a joy to read, which I'm going to do a reading and record for episode 351, me reading the entire filing. I just find it enjoyable to read and to appreciate. And I'm almost like kind of in awe of how the law works and how the Constitution and everything is just set up. I just think it's brilliant. And this is one of the moments where I think that's recognizable, just how brilliant it is. So, and I think AG Bondi's order here is so incredibly bold. And this, I was wrong. I don't think United States v. Comey or United States v. James are going anywhere. I don't think they're getting dismissed based on the appointment of Lindsey Halligan. That ain't happening.